Good morning, everybody. Welcome to the ACC San Francisco Bay Area first program for members and guests. It's the first program of 2022. This is a very beloved appointment for us in January. I am Paola Zeni. I am the Chief Privacy Officer at Ring Central, and I am a member of the board of ACC San Francisco Bay Area. I'm always very happy to attend this session. I learn always a lot from Ian, and thank you to Greenberg Traurig for putting together this program, which is, again, as I said before, like a beloved appointment for all of us. I want to give you a little bit of housekeeping items. This program lasts 90 minutes, 90. So for your CLE credits, make sure you stick to the end. It's not just 1 hour, it's longer than usual. The participants' audio and video are off, so you can focus on speakers and the presentation. The CLE certificate with a copy of the presentation material and a survey will be distributed following the presentation, so you get those after that. And we want you also to be aware that the session is being recorded and will be posted on our website, so you can go back if there's anything you thought you may have missed. We encourage you to ask questions and make this interactive. Use the chat function. So we'll be keeping an eye on the chat for all of you, and just use the everyone to put your questions in there. So I'd like to introduce Ian, our presenter. As many of you already know him, but he is the co-chair of Greenberg Traurig LLP Global Intellectual Property and Technology Practice Group. He's, amazing litigator with a lot of experience. He represents clients in copyright, DMCA, trademark, trade secrets, privacy, security, software, database, and internet, and mobile-related disputes. He is defended cybersecurity breach, ad tech and behavioral advertising, TCPA, and other internet-related class action suits. And hello. Okay. And I would just at this point, there's so much more I could say about him, but I'm eager to listen to his presentation. So without further ado, I'll welcome him to speak to us. Thank you so much, Ian. Thanks for being here.
Thank you, Paula. And it's always a pleasure to be here. And thank you for that very kind and very generous introduction. There is a lot that has happened in the last year. And as every year with ACC, I've got about 5 hours of material that I'm going to try to cover in a much shorter time period. So I'm going to race through things as quickly as I can. Feel free to ask questions in chat or follow up with me after. I've included a number of excerpts. Some of them are page proofs for my 2020 updates to my treatise, which is coming out shortly. And so they are unproofed. There may be errors. Feel free to email me if you want the final version. Feel free to email me if you see typos. We're still working through those, and it'll be in print shortly. If there are other sections that I haven't included in the excerpts that you'd like a complimentary copy of, feel free also to reach out to me either by email or on social media. So as I said, there's a lot to cover this year, and I wanted to provide an overview both of what I'm going to cover and of a couple of issues that are almost standalone that I wanted to raise at the beginning, but I won't have time to get into in detail. So one of the big developments coming up in 2022 is the implementation of the CASE Act, creating copyright small claims, and it is a voluntary process, except if your company is properly served and you don't opt out, you'll be deemed bound by the proceeding. And I think that's going to catch a lot of people off guard when it takes effect. It is set to take effect in June 2022 or sooner. So we will see this, and this will have a big impact this year. I'll talk a little bit more about that in the context of moderation and platform liability, secondary liability later in the program. But the CASE Act implementation in 2022 is, I think, a sleeper issue that's going to catch a lot of companies off guard. I will be talking also about copyright and copyright fair use, and in particular, the Google v. Oracle case, which is a major fair use decision. It's a very strong fair use decision. Between the lines, I think the Supreme Court also has a fair amount to say about copyrightability, which is an issue that was at issue in the case, but the court declined to address. They focused on fair use. So I'll start out the presentation talking about copyright fair use, Google, some other recent cases, and putting that all in context. A theme in today's presentation, expanding First Amendment rights. We see that under the Lanham Act, in the application of Rogers v. Grimaldi, and I'll be talking a little bit about that. I've got an important case pending before the Ninth Circuit. And particularly service providers, content moderation, there has been a tremendous amount of litigation. The whole issue of content moderation has become quite political since the days of President Trump, when he was attacking when he was attacking service providers, so-called big tech. And there have been literally dozens, if not hundreds, of lawsuits brought by Trump supporters alleging an array of concerns about content moderation. The First Amendment has proved to be a very strong and resilient protection for online companies. I realize I didn't include my chapter on First Amendment. There have been very substantial updates to that because there's been so much case law. I'll talk about some of it in the presentation. If this is of greater interest, feel free to reach out to me after the program, and I'll be happy to send you the page proofs for that chapter, which will be published shortly. Secondary IP liability in the CDA, I'll be talking about that. There are a number of important developments, particularly under the CDA, and the CDA has also been challenged politically. First by the Trump administration, which actually issued an executive order looking into whether it could be amended by the FCC. President Biden repealed that executive order in 2021. That was a major development, but we're not entirely out of the woods with respect to the CDA. Senator Klobuchar has a bill which would substantially change the CDA and, frankly, substantially change the internet as we know it. I think it's fair to say that the CDA has allowed most of the innovative internet companies to develop, and many of the early ones, and indeed many of the current unicorns, and not just unicorns, but bread and butter tech companies could not have developed in an era of potentially unlimited liability for user content. So there's a lot of political talk about the CDA. As a litigator who defends cases, I see that in court because it means that judges who aren't familiar with the CDA remember, oh yeah, that's the law that President Trump didn't like, or that's the law that both Democrats and Republicans seem to criticize. And it's unfortunate because it really is a law that has done so much good, but it does come up quite a bit. Whether it actually gets changed, I think remains to be seen. There are more pressing issues in Washington, but certainly all of this chatter about the CDA, particularly under the past administration, made it sometimes challenging for those of us who appear in court litigating the issue. I'm going to talk about AI and data portability. There was an important U.S. Supreme Court decision. In fact, in the area of internet law, there were several important U.S. Supreme Court decisions in 2021. Van Buren v. United States was an important decision under the Computer Fraud and Abuse Act, and it's relevant to a lot of issues, including criminal law, including data privacy, but also including data portability, and whether and to what extent information that's out there can be used. This comes up in scraping, and it also comes up in training data sets. Can you use information that is out on the internet? So it's an important issue. Another issue in the AI space that is quite important, I'm not going to talk about it at length, but it's something to look at for 2022, is that the Federal Trade Commission has signaled that it's going to consider rulemaking with respect to AI as early as possibly February 2022. So that's something to really keep an eye on. I'm going to be, when I talk about data portability in this presentation, I'm talking mostly about ownership rights, who owns the data, either under intellectual property law or under other laws, and who can stop you from taking data, or if it's your data, who can you stop others from taking. But the privacy implications are also quite significant, and the Federal Trade Commission has indicated it's going to address rulemaking, particularly with respect to bias and prejudice. And that's something to keep in mind, because AI is only as good as the data used to train it. And the problem with machine learning is sometimes it learns things too well. There have been some famous studies relating to things like discrimination in home lending. And because of discriminatory practices like redlining, you would have applications that magnify discriminatory impact, because that's what the data to date has shown. So I think that's what the focus of the FTC rulemaking will be on, but it's something to watch very closely in 2022. I'm also going to talk about data privacy and cybersecurity breach litigation, including the CCPA and CPRA. As a litigator, I spend a fair amount of time in court defending cybersecurity breach and data privacy cases. There have been some significant developments in the past year in that area. There also have been other privacy developments, which I want to highlight briefly in this overview slide, but I'm not going to have time to go into in great detail. And that, in particular, in the last year involves developments on the legislative front. There have been dozens of proposals to implement state CCPA-like provisions around the country. But the headline and the important news is that only 2 states beyond California have enacted comprehensive codes. In 2021, Virginia and Colorado adopted CCPA-like statutes. And I say it's like the CCPA. It is not as complex as the CCPA. Neither statute creates an administrative agency such as what we have in California. In 2021, we had the California Privacy Protection Agency open for business. And the CPPA is going to become very important next year in 2023, because it is the FTC-like state agency that is going to administer and implement and enforce the CPRA, the California Privacy Rights Act, which was enacted by ballot initiative in 2020 and replaces the CCPA effective January 1, 2023. Obviously, this year, there's a race by companies to comply with the CPRA, as well as to comply with Virginia law and Colorado law. The Virginia and Colorado statutes, as I said, do not have similar enforcement mechanisms. They're enforced by the Attorney General. They also don't afford a private cause of action. I think that's quite important. I have defended many CCPA cases in litigation, and I'll talk a little bit about that later in the presentation. By one count, there have been almost 200 CCPA cases brought in the past 2 years since litigation first was permitted on January 1, 2020. And many of these cases really aren't CCPA cases, as I'll talk about in more detail when we get to that section. But I do think it's important to note that Virginia and Colorado do not authorize a private cause of action. Both of those laws, like the CPRA, are set to take effect in 2023. That is intended to allow companies time to come up to speed and to implement the laws. But it's also an opportunity for Congress to enact a federal privacy law preempting state law. Whether that will happen is a big open question, and whether it will happen before these laws take effect is a big open question. We have gridlock in Washington right now, and it remains to be seen what will happen. And if Congress passes a federal privacy law, it also remains to be seen whether it would be like the CAN-SPAM Act, which was enacted to preempt an array of inconsistent, burdensome state laws governing email marketing, or whether it would supplement state law, making, for example, the CPRA or similar laws a floor. I shouldn't say similar laws, because actually nothing in the United States is as heavily regulatory as the CPRA. The Virginia and the Colorado statutes are a little bit more streamlined. They also borrow some concepts from the European Union GDPR in terms of data processors and data controllers, but they are similar in terms of creating opt-out rights for consumers and opt-in rights for minors. The opt-out rights in particular raise issues for companies in the advertising space and data brokers and others. Again, it remains to be seen how this is all going to play out. Also, Nevada amended their privacy law. They also have an opt-out right. It is not as broad as California, or for that matter, Virginia and Colorado. But in 2021, new rules went into effect applying to data brokers. So later in the presentation, I'll be talking about CCPA litigation, what will change under the CPRA, and other data privacy litigation. There's been a host of wiretap ad tech cases, so I'll mention those briefly as well. In the cybersecurity breach area, there's also the other development that is quite significant is a very important U.S. Supreme Court case, TransUnion v. Ramirez. I'll talk about it in the context of cybersecurity breach litigation, but it again tightens the standards for federal court subject matter jurisdiction, and that has a lot of implications. The present Supreme Court is very focused on federal subject matter jurisdiction, and it is very conservative. And so this decision makes it that much tougher for plaintiffs to bring cases in federal court, and that much tougher for parties to get court approval when they settle class action cases. The standing requirements are tougher after Ramirez, and I think it reflects a trend, particularly because the court, and especially Chief Justice Roberts, are very focused on Article 3 standing. So that has a lot of implications for the viability of these cases, for settlement value, and also for state court litigation and how much we're going to see happening in that venue. Online and mobile contract formation and arbitration, I'll be talking about that. That's a perennially important issue. I'll be talking about mass arbitration and public injunctions as well. There have been some important new cases and some continuing trends. TCPA and mobile text marketing, I mentioned the U.S. Supreme Court has been active. So far, I've mentioned 3 very important cases: the Google v. Oracle case, the Van Buren case, and TransUnion v. Ramirez. Another important 2020 U.S. Supreme Court digital economy case is the Facebook v. Duguid case. That significantly scaled back the definition of an auto dialer under the TCPA. There has been a tremendous amount of troll-like litigation. So we'll talk a little bit about that towards the end of the program. I think if you're involved in text marketing, it is premature to say that you can just have unrestricted text marketing at this point. Using modern auto dialers that are not an ATDS under the TCPA and the Duguid case. There continues to be a fair amount of litigation. Plaintiffs' class action lawyers have made so much money in this area, they're not willing to give up. And we also now see the development of state law. There is a Florida state statute which defines an auto dialer differently from the TCPA. I actually have a motion pending in a case asking that the court find that statute either should be construed coextensively with the TCPA, or if it is not, that it violates the Dormant Commerce Clause and impinges on free speech rights of mobile marketers. That motion is pending, but that is a concern, and there's been a lot of litigation, particularly in Florida. Links and embedded links. This is the continuing issue of courts in the Second Circuit district courts not following the server test from the Ninth Circuit, and it has put a fair amount of uncertainty, particularly with respect to embedded links. I'll talk about it at the very end of the presentation. 2 other very important important issues that I'm not going to have time to talk about, but I want to raise because I think they're things that you need to be aware of. NFTs, non-fungible tokens, have gotten a lot of attention, and there are IP rights associated with it. To a large extent, though, the IP rights are very standard and very familiar. If you create an NFT from something you created, maybe it's copyrightable. If you take something that someone else created, well, if you don't have a license and it's not a fair use, it may be infringing. And this is something that sometimes people don't consider when they create cool NFTs and sell them for a lot of money. There also are securities law implications to the extent that NFTs are fractionalized or used in other ways. So there are an array of interesting issues. The IP issues so far have been fairly straightforward in terms of, almost any sort of analogous to any time you're dealing with photographs or works of art. If they're yours, you're fine. If they're someone else's, just because you put them in an NFT doesn't mean you are immunized from liability. The final issue that I want to mention that I'm not talking about this year, but is important, is antitrust. Like the CDA, content moderation, and similar issues, antitrust has become a political issue, starting with the past administration, which argued that so-called big tech, whatever that means, should be subject to antitrust rules. This was a reversal of several decades of bipartisan consensus on antitrust. I think it's generally a negative development for the tech world. We have grown up to lead the world in digital technology. While both Democrat and Republican administrations have implemented antitrust laws, really going back to the Reagan administration, there were general views that things that help consumers, help the free market, are not antitrust violations. And that changed in the Trump era, when there was more of a focus on crony capitalism and more of a focus on regulating industries that were seen as not supportive of that administration. And it has extended to the current administration, with the Biden administration appointing some activist antitrust scholars to positions of influence. And so while it remains to be seen where this all goes, and it is, quite frankly, challenging to challenge some of the practices under antitrust laws that have been criticized in the political arena, the reality is antitrust is back, and it is something that you need to consider closely. I didn't include an excerpt, but I'm happy to send an excerpt from my treatise if that's something you're dealing with. So let's jump into to the presentation. Starting with copyright fair use. Copyright fair use, as you know, is based on a multi-part balancing test. There are certain presumptive fair uses, such as criticism, comment, news reporting, teaching, scholarship, or research. But in each case, the court is required to consider 4 factors, and it may consider others. And that's an important point. I've made that point in my treatise for years. I make it frequently when I litigate. These factors are not to be applied in a rigid or wooden way, but they are to be considered, but also other factors can be considered as well. Of these factors, one of the most important is the use transformative. In other words, does it allow the use of an existing work for some new and different purpose? Examples of that have included the unauthorized use of books for the purpose of data mining in the Authors Guild cases against HathiTrust and Google, the use of material for a search engine, an array of different uses. And this concept of transformation came from Second Circuit Judge Laval in an influential law review article that he wrote now more than 30 years ago, which was recognized by the US Supreme Court in the Campbell case. And the Google case really is an important case in going back to Campbell and talking about a lot of first principles on transformation. One of the other factors that has been quite significant in many cases, the effect of the use upon the potential market for or value of the copyrighted work, but also the nature of the work and the amount and substantiality of the portion taken. And courts look at all of these issues. One of my favorite cases, this is from a couple of years ago, but the image is a good reminder. This involved Katz v. Google. I represented Google in that case, and we got Google out of it very early on. The case eventually went up to the appellate court against the blogger. This blogger put this picture of one of the owners of the Miami Heat on a blog, focused on criticizing this person's practices as a real estate developer. It's a good reminder that sometimes in the internet, if you don't like something, you make it worse by filing a lawsuit, because what happened here, this individual was photographed. He didn't like the photograph. He sued the photographer for right of publicity violation. The photographer signed over the copyright, and he started sending takedown notices. And some companies would not take it down because they felt it was a fair use. So he litigated this issue and lost. And now everyone knows this photograph. Here we are at a CLE. We're looking at the photo. And so it's a good reminder that fair use, both under copyright, but also under the Lanham Act and the First Amendment, including under the Lanham Act and for purposes of rights of publicity, provide very strong protection, and that sometimes the things that upset people the most may be the things that you really don't want to litigate, because they may end up just making the blog post or the photo or whatever it is more famous. There have been a number of other other decisions in 2021, including a very controversial decision from the Second Circuit, and that was Warhol v. Goldsmith, involving the musician Prince. And the Second Circuit, in a very controversial decision, ruled that this use, the use on the left, an artistic rendering by Andy Warhol of this photograph, was not a fair use. This is a decision that, as I say, has been controversial. It's been criticized. I should mention at this point, I suppose, that because I litigate cases, and in fact I have some important fair use cases pending within the Second Circuit right now, that of course nothing I say represents the views of my clients, the views of my law firm, or indeed maybe even my own views, and are simply offered to advance the CLE objectives of ACC, and should never be quoted back to me in a brief, please. So with that disclaimer, the Second Circuit found that this was not a fair use just prior to the Supreme Court's decision in Oracle v. Google. And then the Warhol estate petitioned for reconsideration, and the Second Circuit again reiterated that this was not a fair use, saying that Oracle v. Google did not change the analysis. I think I think one can criticize that decision. I think that if you look at the issue of transformation, that particularly after Google v. Oracle, that this decision perhaps should have been decided differently. But I think also there's some unique facts of this case that make it a little bit different, and that goes to the issue of the impact on the market. An unusual issue here is that both the Warhol painting and the Goldsmith photograph were considered for use on the cover of this Vanity Fair magazine. And when it was originally published, Vanity Fair actually paid a license fee to the photographer when they used the Warhol painting. And so because in this unique instance, the two works actually were competing, it's different from, I think, a lot of cases, an unusual instance where a photograph was used in a way where there was actually evidence of impact on the market. But even what the Second Circuit had to say about transformation, I think can be criticized. To a large extent, the Second Circuit relied on case law predating Campbell. Remember, I said Campbell was the US Supreme Court decision from many years ago, which adopted transformation. And so the Second Circuit reached this decision really by reaching back in time to other art cases that predate Campbell, that predate the adoption of transformation, and that predate both Campbell and Google v. Oracle. And so I think on that basis, it can be criticized. I actually have a chapter coming out on the intersection of copyright, fair use, and technology in a book on art law that's being published in early 2022. And in that, I do discuss more, again, just my personal opinion, that I think the Second Circuit relied too heavily on pre-transformation case law in reaching this decision. Another case from 2022, this is 2021, sorry, getting a little ahead of myself here in the second week of 2022. But another case that is interesting and of note involves this photograph, and whether this photograph was a fair use, O'Neill v. Radikowski, and that case involved a motion to dismiss, and the court said very hard to decide those on a motion to dismiss. But the interesting thing there, this is a paparazzi photograph. I think the case, even though it's an unreported decision, has gotten a fair amount of attention because it involves a celebrity and because it involves the use of social media. But I think it also underscores the fact that the largest number of cases filed in the United States these days as copyright cases are brought by photographers, and many of them are paparazzi photographers, or even just freelance photographers you might not have heard of. They take photos. Sometimes they try to make them go viral on the internet, and then they sue websites and other companies that end up using the photos. So it is a phenomenon to be aware of. In this instance, you have a photo that had been reposted by the actress. It was of her holding flowers, and she thought that it was an interesting photo. She assumed it had been taken by the person who posted it. And again, that's also one of the problems on the internet and social media. You don't always know who's the copyright owner. But I think actually you can make an argument that the fair use issue here is even stronger, not only because of the commentary, Mood Forever, and the fact that that her face is hidden, which has significant commentary. But if you look at the way most Instagram posts appear, like this one, for example, of me on Father's Day, you see it's not just the picture, but also the other factors. Is it liked by people? Have people issued, have people given comments? And the commenting on that also may be significant. This, of course, also is just a shameless attempt to garner smiles from my adorable children, but it is also a serious point about the use of photos and art in social media. So it's an interesting case. It's one to follow. As I mentioned, I have a couple of fair use cases in litigation presently, and I think there are a lot of developments coming up in 2021 that in the intersection of copyright, fair use, the First Amendment, art, and the use of social media. So let's talk about Google v. Oracle. It was a complete win, and it is a significant win because the Supreme Court found not just that the use was transformative, but that every one of the fair use factors weighed in favor of fair use, and that's a very significant holding. It's not every day that the Supreme Court focuses, on all four of those issues. Google v. Oracle involved the re-implementation of APIs. Google created original code, but in order to make it interoperable, it copied the APIs or interfaces. I represented Google at the trial court in the copyright case, so I can't say too much about it. And of course, as I said before, nothing I say represents the views of my clients or my law firm or even myself. But I do want to talk about the Supreme Court decision as an important one on fair use that has broad implications, both for fair use and for copyrightability, because the Supreme Court did hold that that all four factors weighed in favor of fair use. So it was transformative. What was interesting was, so one interesting aspect is discussion of the Supreme Court of impact on the market, because Oracle argued that that Google's use of the APIs to create the Android operating system destroyed its ability to create a mobile operating system, or really gain traction, because there was a mobile operating system for Sun, and that that it therefore adversely impacted the market, which the Federal Circuit had agreed with. And the Supreme Court said that that really wasn't the case, that certainly Android damaged the market for Sun mobile applications, but not because of the alleged copyright infringement, because of an array of other issues, including limitations of Sun's own mobile system. And that was very important. And the court also focused very heavily on developers as the relevant market. That in looking at the market, it wasn't just the impact on Oracle, but the impact on developers, which it found to be very positive and pro-competitive. So that was quite significant as well. The nature of the work, the court concluded that it weighed in favor of fair use, but also noting that the declaring code, or the code used in the APIs, if it's copyrightable, if it is copyrightable at all, is entitled to very thin protection. Again, that was very significant. The court spent a fair amount of time in its opinion talking about how limited the level of protection is for software copyrights, and that software is primarily functional. So a program certainly can be copyrighted, and if the program is copied, that certainly would be infringing. But because the Supreme Court talks about these different levels of protection and holds that that software is primarily functional and entitled to a lower level of protection, this also goes to software copyrightability, because you have a long line of cases in this area. I'm going to skip ahead a little bit and then slide back. But you have a long line of cases that for decades established the parameters of software copyrightability. There are various elements of a program that are entitled to protection. That can include the literal code, non-literal elements of the program, user interface, or appearance. But again, to a lower level of protection. And because of the Feist decision in 1991, rejecting the sweat of the brow doctrine, facts are not entitled to protection, even if a lot of money, time, and energy was spent in developing those facts. And by analogy to software, functional elements dictated by the nature of the program, the nature of the operating system, things of that nature are not entitled to protection. And the leading case in that area for decades has been Computer Associates v. Altai, which adopted an abstraction filtration comparison test. Also important was Lotus v. Borland, involving a method of operation, finding that that a method of operation was not entitled to copyright protection. One of the reasons that I think the Supreme Court's decision is quite important, not just on fair use, but to software copyrightability, is because of the extent to which the majority speaks of software in the language of Computer Associates and the language of Lotus v. Borland, and cites those cases. The Federal Circuit in Oracle v. Google took more of a maximalist approach. The Federal Circuit decision is inconsistent with those decisions. It arguably, frankly, was inconsistent with Ninth Circuit law, even though it was purporting to apply Ninth Circuit law. So the Federal Circuit decision on copyrightability is still technically good law, but I think it is actually inconsistent with the US Supreme Court decision. And what the Supreme Court has to say about copyrightability, about functionality, about low level of protection becomes, I think, very relevant in cases that don't involve literal code copying. Obviously, if you have a program, someone copies it, that's infringement. But a lot of the issues, including really in the Oracle case too, involve what I would call non-literal elements of the program, what the program does as opposed to how it does it, and the interfaces, in this case, APIs. So I think that that's going to be an important decision. There is actually a case coming out of the Eastern District of Texas, the SAS case, addressing that very issue. And I think that there's a lot of material in the Supreme Court's decision that could be relevant. But as a practical matter, because of the way the Supreme Court decided the case, opting not to address copyrightability head on and whether the APIs themselves were protectable, but deciding instead on fair use, I think in litigation, a lot of courts will rule the same way. It's just easier not to deal with copyrightability if it's a tough question in light of a Supreme Court decision that's on all fours. But of course, fair use decisions are more difficult to address on motions to dismiss. Typically, you have fair use is usually addressed on summary judgment, sometimes, as in Google Oracle, at trial. But I do think that those are some of the significant developments. And as I say, because the Supreme Court found fair use, found all of the factors weighed in favor of fair use, it is a very significant decision, not just in the software area, but also in other areas as well. And it's going to continue to be an influential case. Let's talk a little bit about First Amendment limitations on the Lanham Act. I mentioned at the outset the First Amendment, there's been a lot of important First Amendment case law in 2021, including especially in the service provider area, dealing with content moderation and other issues, which I'll get to a little bit later. But let's talk about IP, because again, as I mentioned, under copyright fair use, sometimes uses that you don't like may not be the uses you want to sue over if there's a First Amendment or fair use issue. There's been a lot of litigation in recent years under Rogers v. Grimaldi. Rogers v. Grimaldi is a First Amendment test first articulated by the Second Circuit, involving a suit by Ginger Rogers. There was a Fellini movie, Fred and Ginger, about these two people in Italy who did not dance anything like Ginger Rogers and Fred Astaire, but they fancied themselves to be Fred and Ginger, and they traveled around a delightful movie. Ginger Rogers filed suit claiming that this was trademark infringement because the Ginger of Fred and Ginger was clearly intended to be Ginger Rogers. But the Second Circuit found that this was an artistic use and it was protected by the First Amendment. In the decades since Rogers v. Grimaldi, the test has been extended beyond just titles, and the concept of artistic use has been expanded beyond just literally a film to an array of uses involving First Amendment protection. Dr. Seuss, the Connectics, that's actually 13 months old, so it's really from last year's year in review, but I mention it again because it's a good reminder of how Rogers v. Grimaldi is a different test from fair use. In that case involved a book that was a mashup of Dr. Seuss and Star Trek, and the court found it was not a fair use under copyright law. But it was protected by the First Amendment under Rogers v. Grimaldi. It's really a reminder, and I constantly address this issue with clients and in litigation. When you're dealing with uses, particularly artistic uses on the internet, in social media, in the digital realm, you need to be looking at copyright, trademark, rights of publicity, and not just the claims, but also fair use. Lanham Act fair use is different from copyright fair use, and also the First Amendment, which can provide a whole additional layer of protection. And again, Dr. Seuss is a good reminder of that. Not a copyright fair use deemed potentially infringing, but protected by Rogers v. Grimaldi, no Lanham Act claim. VIP production involved a dog chew toy. And so that even a chew toy can be entitled to First Amendment protection. Punchbowl v. AG Press was a case where I represented Punchbowl News. If you are not yet a subscriber, it's a good service to look at for inside the Beltway politics. That was a lawsuit brought by Punchbowl, which is an online greeting company, and they objected to the use of Punchbowl by Punchbowl News, which uses an inverted U.S. capital, because Punchbowl is the Secret Service code name for the Capitol, and Punchbowl News is an inside the Beltway political publication by several veteran journalists and opinion makers who literally have an office in the U.S. Capitol and write about inside the Beltway issues. We prevailed in that case, and the case is now on appeal, and there have been some amicus briefs filed in our support by some law professors and some independent creators supported by the Electronic Frontier Foundation. The test is, I think, worth looking at also because it is a different test than the Lanham Act test for fair use. It's also a different test than the Lanham Act test for likelihood of confusion. And it really focuses on a series of different questions, which is, is the use expressive? So that's the first question. And if so, does the secondary use have some artistic relevance? That second prong, very low standard. If it does have some artistic relevance, then the question is the use explicitly misleading? And that's a high standard. It's not the same as likelihood of confusion. It generally, in the Ninth Circuit, looks to the degree to which the junior user uses the mark in the same way as the senior user, and the degree to which the junior user has added his or her own expressive content. And if the accused use has some artistic relevance, and if it's not explicitly misleading, then as a matter of law in the Ninth Circuit, it is protected by the First Amendment. It's an important limitation on overly aggressive trademark use, sometimes called trademark trolling, where trademark owners try to expand their rights beyond what the Lanham Act permits, beyond what what is reasonable, and to allow free expression and expression protected by the First Amendment. So this is an area again to consider as you're using works in social media. It's not just the elements of a claim, it's not just fair use, it's also the First Amendment. And that is a good lead-in to secondary IP liability and the CDA, content moderation, platform and marketplace liability. This is an area where there continues to be a fair amount of litigation. The parameters remain clear, but there are a lot of new developments. So let's jump in. In the copyright area, the DMCA provides notice and takedown. There's not been a lot of new circuit court decision in 2021. And good news, the Copyright Act the Copyright Office in 2020 recommended against any legislative amendment to change the CDA. I had testified at the invitation of the Copyright Office on this issue back in 2016, and it took over 4 years before the report came out. But following that report, 2021 has been a relatively quiet year in the DMCA. Obviously, a lot of district court litigation, still a lot of cases in litigation. But one important issue I mentioned at the outset that is going to impact service providers and platforms in 2022 is the implementation of the CASE Act, because the CASE Act creates a small claims board, and the Copyright Office is going to establish that board by June 2022. I have included an excerpt from my forthcoming 2022 updates that discusses the CASE Act in detail. If you didn't get it, I'm happy to send it to you. There's a lot to look at. It really only covers 3 kinds of claims, but they're claims that platforms, marketplaces, and internet intermediaries need to be aware of. And it's really a statute that a lot of companies, I think, are going to miss. It's going to come under the radar because it's been heavily publicized that CASE Act proceedings are voluntary. And so, a lot of people think, well, it's voluntary, I don't need to worry too much about it. The problem is if you are properly served with a CASE Act complaint and you do not opt out in 60 days, you are bound by the result. So even though it is voluntary, it's an opt-out kind of voluntary. And so I think that's something that companies need to really be aware of, because at the latest, June of 2022, you're going to start seeing these claims come in. As I said, it only applies to 3 types of claims: infringement of an exclusive right in a copyrighted work by a legal or beneficial owner, for which the claimant seeks damages. And I should say it's small claims. So the damages are limited, $30,000 per proceeding, plus fees and costs, attorney's fees up to $5,000. So, for major disputes between companies, this is not something you're going to want to use. But $30,000 in a claim where you don't need a lawyer, if you're a copyright troll, if you are a paparazzi photographer, if you are someone who spends a lot of money on federal court litigation, this may be appealing, especially if the company you're suing doesn't realize that they have to opt out in 60 days or they're going to be bound by the result. So the first type of claim I mentioned is infringement. The second one is non-infringement. So essentially like a declaratory relief action of non-infringement. And the third is misrepresentation in connection with a notification of claimed infringement. So this is going to impact service providers in a couple of important ways. First of all, because 512F claims can now be brought in this small claims venue, it means that we're probably going to see more 512F claims. Now, if you are a company that sends DMCA notices, that means you need to be more careful, because for any company that has to deal with small claims court proceedings brought by consumers, that if you get enough of these kind of proceedings, even at $30,000 a pop, that starts to add up. It's time, it's money, it's a burden. So you have to be perhaps more careful to make sure that your DMCA notice complies with the law, and that you're considering fair use, which at least in some circuits has been deemed implicit as an obligation of the copyright owner in sending a copyright notice. It also means that service providers themselves can bring these kind of remedies against copyright owners that are using the DMCA in an abusive way, if they want a cheaper venue to bring it, and that there may be claims by users as well. Now, the declaration of non-infringement is an important point, because that also means we're going to see more action involving counter notifications for companies that employ counter notifications, because as you probably know, under the DMCA, if a copyright owner sends a takedown notice, the service provider has to take down the material, unless the user submits a counter notification, basically certifying under penalty of perjury that they have a right, because they're licensed, because they think it's a fair use, because they created it, because they think it's a mistake, whatever the defense is. And then if a counter notice is submitted, the service provider has to put the material back online unless the copyright owner files a lawsuit. Well, because of the Case Act small claims proceeding, now a copyright owner that maybe doesn't want to, to spend hundreds of thousands of dollars or more in a federal copyright claim, the copyright owner could instead submit a Case Act determination, and that would keep the material offline. Similarly, the user could bring suit for a declaration of non-infringement. So I think we're going to see a fair amount in this area. I could be wrong, but I think it's certainly something that companies need to be very aware of, and because it can slip under the radar. But particularly for companies that send or receive DMCA notices, you really should become very familiar with the Case Act. In the trademark litigation area, there have been a couple of decisions in 2021. One of them, Ohio State v. Redbubble, was reversing a decision at the district court that had held that simply because a platform or marketplace allows users to list items for sale does not mean that they are offering to sell a product for purposes of the Lanham Act. And the Sixth Circuit reversed. It doesn't mean that Redbubble lost. And indeed, Redbubble has had some very good victories in other cases. But it was a statement that the district court was too broad in saying that there was no use in commerce. So another decision actually from 2021, YYGM v. Redbubble, summary judgment for Redbubble on direct and vicarious claims. There was also an Atari case with mixed results, some good rulings, but sort of a mixed result. In the trademark area, there's been a lot of litigation. And some of it does deal with print on demand and other companies, and that's something to be aware of. In the patent litigation, I mentioned this case of mine, Blazer v. eBay, even though it's a few years old, because that was the application of these same principles to patent law. In that case, the court in Alabama agreed with us that eBay was neither selling nor offering to sell any products simply because a user offered to sell something on eBay and another user purchased it. So putting a listing in a marketplace is not a sale or offer to sale under the Patent Act under that case. And it's, again, also a reminder when you're dealing with marketplace and platform liability, the copyright, trademark, patent, the cases have similar approaches. The courts look from one to the other, but the standards are also different. And so similarities and differences are to be considered. Let's turn to the Communications Decency Act. There's a lot going on in that area. Just briefly, for those who don't spend time as I do litigating in that area and updating my treatise on this issue, the CDA provides immunity for interactive computer service providers or users for republishing third-party content under C1. And it also provides broad protection under C2 for any act taken in good faith to restrict access to or the availability of material that is viewed as objectionable or otherwise harassing. But there are certain exceptions: FOSTA, SESTA, federal criminal claims, claims under ECPA, or any similar law, and any law pertaining to intellectual property. As of 2021, we now have a circuit split on that issue. What is any law pertaining to intellectual property? So let's drill down on that a little bit, because from 2007 to 2021, the only circuit court decision was the Ninth Circuit decision, which construed the exclusion for intellectual property very narrowly and construed the scope of preemption under the CDA very broadly. And that was the Perfect 10 v. CC Bill case. In 2019, the Supreme Court expanded on that concept, talking especially about the statute, the structure of the statute, the policies behind it, and why it was important to narrowly construe intellectual property to just federal intellectual property, federal patent, federal copyright, federal trademark, and not state claims. Indeed, in Enigma Software found that a Lanham Act claim was subject to CDA immunity because it was not based on a trademark. A Lanham Act false advertising claim, not premised on trademark infringement, was found to be subject to CDA immunity. Marshall's Locksmith found the same way. DC case also from that year, and Marshall's Locksmith also found Sherman 1 and Sherman 2 claims preempted under antitrust law. But in Hep v. Facebook, the Third Circuit construed the exclusion for intellectual property more broadly and found that the exclusion for any claim pertaining to intellectual property applies not just to federal intellectual property claims, but also to state claims. And they looked at the language of the statute. When you have exclusions for federal criminal prosecutions, the Federal Electronic Communications Privacy Act, or any similar state law, when you have these exclusions that reference federal, state, and then you have one that says any claim for intellectual property, the Third Circuit construed that to mean both federal and state. So in the Third Circuit, service providers cannot rely on the CDA for right of publicity claims. That was a right of publicity case. State trademark claims, state trade secret misappropriation claims. So we have a circuit split on that issue. A couple of other IP issues just to show that Congress has been thinking about this issue. The Orangey Hatch Bob Goodlett Music Modernization Act of 2018 ruled that the Music Modernization Act was a law pertaining to intellectual property, meaning that the CDA did not preempt, or actually, because it's a federal law, not preempt, but preclude any claim, although in that case, the DMCA provides protection. And then the Defend Trade Secrets Act, this was an unusual one. The Defend Trade Secrets Act, it doesn't say it anywhere in the statute, but it is clear in the in the bill itself, and it's a footnote in the U.S. Code. I discuss it extensively in my treatise, that the Defend Trade Secrets Act is not a law pertaining to intellectual property. Now, anyone who's gone to law school and taken a class involving trade secrets knows that actually trade secrets that is a form of intellectual property law. But what Congress meant in saying that the Defend Trade Secrets Act is not a law pertaining to intellectual property is they meant to say that for purposes of the CDA immunity applies. The DTSA will not override CDA immunity. So you now have the weird circumstance in a trade secret infringement claim brought against an interactive service provider, where if the claim is brought under the Defend Trade Secrets Act and state law, the service provider will have CDA immunity if they're otherwise entitled to it on the Defend Trade Secrets Act claim. But whether they have it on the state law claim depends on the circuit where the suit is filed. In the Ninth Circuit, you would have CDA immunity. In the Third Circuit, you would not. Anywhere else remains to be seen. So that's an important development to be aware of. In this slide, I mentioned some recent cases and also just highlight some of the major cases in this area, because I think it's always important to remember that the Ninth Circuit has sort of almost an unusual approach to the CDA. We have a number of very narrow exceptions that almost create like Swiss cheese holes in CDA protection. They're often so narrow that it's very hard for most plaintiffs to squeeze through them. But the Ninth Circuit has a lot of exceptions, and that can allow plaintiffs some games when they plead things. The 10th Circuit has some good case law, but also one FTC case that's a little bit concerning. And the 7th Circuit, they have some good case law, but also some Easterbrook decisions, suggesting that maybe the CDA should be considered in a completely different way. On the other hand, the First Circuit, the Second Circuit, the Fourth Circuit, the Sixth Circuit, and the DC Circuit have very, very broad applications of the CDA. And, when I'm litigating around the country, if I'm in a circuit with very strong CDA law, there's sometimes a tendency by companies based in California to look at things from the prism of roommates.com and Ninth Circuit law. And honestly, there's so much better law out there in other circuits. So something to keep in mind when you deal with these cases around the country. Although, as I mentioned at the outset of the program, something to be very aware of and very important is that that because of some of the criticism of the CDA by former President Trump, by Senator Klobuchar and others who are trying to amend the law, judges who have not considered the CDA find themselves, maybe a little more skeptical. And that's an issue that we have to deal with when we litigate. It's sort of a background atmospherics. And remember, the federal judiciary, there's a significant turnover. Back when I first started practicing law in the olden days when dinosaurs roamed the earth, a federal court appointment was a life tenured appointment, and judges served for many, many years. In recent years, it becomes more common for federal judges to have a significant career for several years and then retire at the jams or go in-house or even go back to private practice. And so as judges make more career moves, there's a big turnover. We saw, for example, that by his fourth year in office, President Trump had nominated more federal court judges than any other president. President Obama achieved that distinction in his second term in office, as did President Bush in his second term in office. So it's a reminder that there's a big turnover. And the federal judiciary, it's important to know who your judges are. As a litigator, again, when I first started practicing law, there were fewer resources available, and it was more typical that decisions were issued, and you assume judges are calling balls and strikes. Today, the first thing I look at is I look at Lex Machina statistics. I want to see big data on the judge. What have the judge's rulings been? How long does it take the judge to decide a ruling? What percentage of motions to dismiss are granted? What percentage of defendant summary judgment are granted? What percentage of plaintiffs summary judgment are granted? All of those data points are very relevant to how strategically you litigate a case. But these background atmospherics can also really impact, as well, again, as the inclinations of the judge. And the more that politicians try to make neutral laws political, the more challenging it is to litigate these cases. Lemon v. Snap was a decision where the Ninth Circuit found no immunity in a negligent design case. That conflicts with the decision from another circuit. Is significant in that regard. Conduct is content. Because conduct on the internet takes the form of content, a lot of the decisions in this area involve not simply defamation claims, but claims brought for misconduct. A 2021 decision from the Ninth Circuit, Gonzalez v. Google. These were claims brought into the Justice Against Sponsors of International Terrorism Act over terrible acts of terrorism, but again, trying to hold platforms liable because bad people use the platforms. Court found that was barred by the CDA, although the court said the CDA didn't bar claims based on sharing of ad revenue. Again, another one of these Swiss cheese provisions. I don't know that a lot of the other circuits would have ruled the same way on that point. In any case, plaintiff didn't state a claim, but it's also a reminder the Ninth Circuit seems to take this Swiss cheese approach to the CDA. Very strong, similar opinion, but winning on all points. Force v. Facebook from the Second Circuit, and similar cases. I mentioned the executive order. President Trump had issued an executive order asking the FCC to consider whether it could regulate platforms and whether it could issue rulemaking under the CDA, which really would be unprecedented because the CDA is a provision in the Telecommunications Act of 1934 that is not subject to the rulemaking provisions. In any case, that executive order was repealed by President Biden in 2021 in an executive order from May of 2021. There is no more discussion of federal regulation through the FCC, which is good news. An interesting decision, I want to just say a quick word about it. For those who follow the CDA, there have been so many decisions in 2021 in the Doman v. Vimeo case. There were two separate the Second Circuit decisions before it was withdrawn. The end result is fine, which is plaintiffs' claims were dismissed under both CDA 230C1 and 230C2. There was a very good Second Circuit opinion leveraging off of a very good Ninth Circuit opinion, really broadly construing subpart C2, the provision that's not litigated that often. And then the Second Circuit withdrew the decision and ended up issuing an unreported decision affirming the lower court on completely different grounds. So there was a lot of drama in 2021 on that issue, but ultimately those opinions were withheld. I want to mention very quickly before moving to privacy and security, some other non-CDA issues to be aware of. So terms of use, there has been a tremendous amount of litigation over terms of use. In the Doman case, terms of use turned out to be incredibly important in supporting a defense verdict. Whether it is enforceable as a contract or not, it gives a service provider well, first of all, if it's a contract, it gives the service provider the right to terminate for breach of the provision. We saw that in the Parler v. Amazon Web Services case. Many of you remember Parler, which is an alt-right social network. After the January 6th insurrection, Amazon Web Service discontinued service because it turned out that Parler had been used by some of the organizers of the attack on the US Capitol to organize that attack. And Amazon said that was a violation of their acceptable use policy, and Parler sued and was unable to prevail because the court found that that was, that Amazon had that right to enforce their acceptable use policy. Similarly, under the CDA, even if it's not a contract, it would support a CDA C2 provision. There have been some state laws in states trying to regulate social media companies, again, leveraging off this Trumpist notion of big tech. And an important decision in 2021, Net Choice v. Moody, District Court in Florida, preliminarily enjoined enforcement of Florida's anti-social media law, finding that it violated the First Amendment. There's some significant dicta from 2021. Justice Thomas, concurring in Biden v. Knight First Amendment Institute, suggested that even though social media companies are private companies, which of course they are, saying that it seems sort of strange that a private company holds the right to suspend the account of a president. This was a case brought by Trump over his suspension from Twitter, actually initially over some deletion of some posts. And that's why ultimately when he left office, the case became Biden v. Knight First Amendment. The court found the case was moot, but lower courts and the Second Circuit in this case have consistently held that private companies have the right to moderate content and that they are not government actors. So there are dozens, if not hundreds, of lawsuits brought by people claiming they have a First Amendment right to use social media companies for abusive practices, to engage in various practices that violate terms and conditions. And courts have essentially almost uniformly upheld them. An important 2020 decision, Prager v. Google, held that private companies are not government actors. 2021 decision, Lewis v. Google, the same thing. Finally, let me mention there's a circuit split under anti-SLAPP law. A number of circuits including most recently in 2021, the DC Circuit have held that anti-SLAPP statutes enacted in various states are procedural laws, not substantive laws, therefore not applicable in federal court. The DC case is significant because it reaffirmed a decision by Justice Kavanaugh when he was a DC Circuit judge, holding that it was a procedural rule. The Ninth Circuit, however, holds that the California law is substantive and therefore is applied in federal court. The Ninth Circuit has also applied the Texas anti-SLAPP law as a substantive law, even though the Fifth Circuit has ruled that the Texas law is a procedural law, and the Second Circuit has ruled that the California law is procedural, even though the Ninth Circuit says it's substantive. So there's a significant circuit split, and that comes up a lot in speech cases, and you should be aware of it. There's also a lot of litigation involving marketplaces and whether something is or isn't a sale if the CDA doesn't apply. And there have been some significant decisions in 2020 and 2021 on those, including a big victory for Amazon from the Texas Supreme Court, which I realize I omitted to put on this slide. I apologize. Huge victory in the Texas Supreme Court. Let's turn to artificial intelligence, screen scraping, and privacy. In the AI area, I mentioned the FTC may be issuing some rulemaking on discrimination and privacy. But in general, there are a panoply of potential remedies, but it's really, I look at it as a smorgasbord of remedies because there's not a single federal anti-scraping law. This whole issue of scraping is very important for AI because machine learning depends on data sets. AI is only good as the data that was used to train the algorithms. And so it's very important for machine learning and for AI to have good data sets. Can you get that data? Well, facts are not protectable under the Copyright Act, but entire databases are potentially protectable. I've included the entire chapter from my treatise on database protection, screen scraping, and AI machine learning. Because this is a very big topic. I'm also happy to take questions and talk about it online. But typically, copyright usually doesn't apply unless an entire database is copied. If it's copied and used for intermediate copying in a way that then may be a fair use or may not be a fair use, raises a lot of complex issues. There are a lot of common law claims that can be raised unless they're preempted. Trespass and conversion. Conversion usually doesn't work because conversion requires not just that you copy something, but take it. Trespass in most, but not all jurisdictions, requires that there be substantial intermeddling or harm to the servers. Computer Fraud and Abuse Act. I mentioned the Van Buren v. United States case, U.S. Supreme Court, important decision holding that a policy violation cannot be the basis for a Computer Fraud and Abuse Act claim. Computer Fraud and Abuse Act is a federal anti-trespass statute. It prohibits unauthorized access and exceeding authorized access, and the Supreme Court held that if you are authorized for one purpose but not another, and it's a policy violation, an employment policy, terms of use, that is not going to be actionable. So that limits to some extent the Computer Fraud and Abuse Act, but honestly, you can, if you are trying to protect data, you can just send a cease and desist letter. You are not allowed to use this. HiQ v. LinkedIn, Ninth Circuit decision from earlier, finding a very narrow exception on a preliminary injunction, not as a final ruling, saying if the information is publicly available, as opposed to privately listed, you can't block it, but you could under other provisions. The things to look at in this area: Copyright Act because of statutory damages, although it's thin protection; anti-circumvention provisions of the DMCA because of statutory damages. That can be quite significant, and that can really add up. So you have to be aware of that. There also are some, very narrow statutes. Well, and also removing, altering, or falsifying copyright management information. That can be, again, statutory damages, so there are issues. CDA also may apply, though. Callahan v. Ancestry.com is a good example of that. The CDA may insulate a company. So let's talk about security breach, data privacy, and ad tech putative class action litigation. There's been a lot of activity in this area. There also are an increasing number of securities fraud claims brought over cybersecurity incidents. In re Alphabet is a recent Ninth Circuit case, 2021, where Alphabet prevailed. Facebook, an earlier case dismissing claims for lack of causation and reliance. I have to say, in all of the cybersecurity cases that I defend, reliance and causation and damage are often very, very significant issues. And the reason that these cases, if they settle, often settle for lower numbers than you might expect. At least in the securities fraud area. I mean, not securities fraud, in the cybersecurity breach area. There are an array of federal claims in the excerpts on data privacy litigation and cybersecurity litigation. I go into those in greater detail. There's a lot of litigation under the Illinois Biometric Information Privacy Act because there's the ability to get statutory damages. And that is the key. If there's statutory damages, the class action lawyers love it. That's also why there's been so much CCPA litigation, which I'll talk about in a moment. But also breach of contract claims. A big issue in all of these cases, if you can have privity of contract, or if you're not in privity of contract with users, if you can make yourself an intended beneficiary of their contract and have a binding and enforceable arbitration clause, I think that's going to be very important. I litigate that issue over and over, and that is an issue that just does not go away. Is there a binding and enforceable arbitration clause? I'm going to talk in a couple of moments about some developments in that area, including mass arbitration. Typically, the way I defend these cases, I try to see if we can knock it out on a motion to dismiss. If not, can we knock it out on summary judgment? Of course, you get to class certification. We can defeat those, but oftentimes you don't get there. Also, if there are multiple suits, is it something for MDL certification? The Dickey's case that I list there is a case where I successfully defeated a motion for MDL certification. We had a number of cases pending in California and Texas. We ended up actually getting transferred all of the California CCPA cases to Texas. And so they're all now pending in the Northern District of Texas. It's a reminder that CCPA litigation can take place anywhere. It's a reminder that not every cybersecurity case needs to be an MDL case. Work product is also an important issue. We talked about this a lot last year. When there's a security breach, it's important to involve your litigators, because the Capital One case held that if there are dual purposes for a forensic report, both litigation and business purposes, it can be discoverable unless the litigation was the driving force. Now, the Ninth Circuit has a very different test. The Ninth Circuit, if it's a dual purpose, if one of the purposes is litigation, it's privilege. In 2021, the Ninth Circuit in re grand jury subpoena addressed attorney-client privilege. And the attorney-client privilege rule is a little bit different. And the attorney-client privilege rule is similar to the Fourth Circuit rule in work product, where the court said, well, what is the driving force, or what is the dominant purpose? And if the purpose is both business and litigation, then it may the privilege may not hold. So in the Ninth Circuit, attorney-client privilege will not get you as much protection for a forensic report as work product. And the Ninth Circuit reaffirmed that the work product rule is different. But again, if you're operating nationally, you can't rely on just the Ninth Circuit rule for work product, because you may be subject to the Fourth Circuit rule. Another issue that comes up, and I've dealt with that, when you're dealing with a security breach, if you know you're going to get sued, you may want to hire a litigation consultant right out of the bat. You don't, if you're not a regulated entity, you may not even need to have a forensic report. And so maybe you just hire a litigation consultant and everything you do is protected under Rule 26, a completely different independent basis beyond work product and attorney-client privilege. So something to consider, but something to be aware of. In the data privacy area, I mentioned there are a lot of ad tech cases. There was an explosion of litigation at the tail end of 2020 and the first half of 2021 brought against technology companies involving replay technologies that allow companies to replay use of a website to find things like dead links. Basically, these are website optimization tools. But plaintiffs said that these were listening devices, surveillance devices, and they sued mainly in California or under California law, but also in Florida. And so far, the courts have knocked them out. I have one case left pending in a court on the East Coast. Most of the cases I've either won or the plaintiffs have dropped. There have been a lot of this litigation, but courts in California, in the Noom case and others, have found SIPA, the state wiretap statute, generally to not be applicable in this instance. And Florida courts, following on the Jacome v. Spirit Airlines case, have found similarly. In the cybersecurity area, standing is an important area. I mentioned at the outset, TransUnion v. Ramirez is important because the Supreme Court tightened the standards for standing. Under Clapper, you can have standing if you have a threat of future injury, which is typical in cybersecurity breach class action cases, because you're dealing with plaintiffs who generally don't have out-of-pocket monetary harm. But Ramirez tightened Clapper and said Clapper only applies for injunctive relief. It doesn't apply for a claim for damages. So what does that mean? There's a significant circuit split in the cybersecurity breach area right now, as shown on this board, where you have courts in a number of circuits taking a more conservative approach, which I think is the one more consistent with the US Supreme Court, where if you don't have a present economic injury, you are most likely not to have standing. And then there are more liberal circuits, the Seventh Circuit and the Ninth Circuit and the DC Circuit, where, you know, if you have out-of-pocket expenses, if you have harm, if you have mitigation expenses, not harm, if you have mitigation expenses, these are considered to be harms. I think the more liberal approach is inconsistent with Ramirez. I think the Supreme Court will probably resolve this, and I think they will further tighten the rules. Now, I'm loath to predict what the Supreme Court will do. I had a case before the US Supreme Court that we won 9-0. It was a copyright class action case, but it remained in litigation another 9 years. The Second Circuit found a way to vacate our decision on different grounds. So I'm hesitant to predict what the US Supreme Court does in any case, but in this instance, I think it's fairly clear. I discussed this extensively in the 2020 update to my treatise. I didn't include the page proofs, I'm sorry. I'll be happy to send that to you offline if you deal with it. The CCPA, this is very important. There's been a lot of litigation in this area. In my treatise, and I did include an excerpt from the forthcoming excerpt, I think that there's basically like a 7-prong element for a CCPA claim. There have been a ton of these cases. I mentioned that there's almost 200 of these lawsuits that have been filed. Most of the cases that have been filed really are not actually CCPA cases. They involve breaches that predate the CCPA. They don't involve personal information within the meaning of the CCPA, defined very narrowly. It's not the broad definition of privacy. It's the narrower one from 1798-150. It has to be subject to an unauthorized access or exfiltration, theft, or disclosure as a result of a business's violation of the duty. So if you are not a business under the CCPA, you can't bring a claim. If a plaintiff is not a California resident, you cannot bring a claim. I can't tell you the number of CCPA cases that I've gotten that we get rid of because they are not CCPA cases. I also got final approval on what I think was the first CCPA class action settlement. And, you know, the numbers are often not as high as you would think, given that the plaintiff can get, you know, up to $750 per claim. And part of the reason is because of even in a statute like this, you still have standing issues, you still have arbitration issues. Now, of course, if standing becomes insurmountable, plaintiffs sometimes bring suit in state court in California, in Illinois, in other states where they like to be in state court. In fact, in Illinois, because of the Illinois Biometric Information Privacy Act, these days you often see companies arguing that there is federal court jurisdiction, and it's the plaintiff that says, no, there's no standing, remand us to state court. Interesting turn of events. The case law under the CCPA, you can sometimes get claims dismissed. In the excerpt from my treatise that I've included, I talk about the kind of claims that are subject to motion to dismiss, the kind of claims that are subject to summary judgment. The CPRA doesn't change the claim that much, and there's still the 30-day remediation notice law. Under the CPRA, for most elements, including regulatory enforcement, that 30-day notice and opportunity to cure disappears, but not for litigation purposes. That remains. Although under the CPRA, claiming that you've adopted reasonable security is not sufficient for mitigation. So the CPRA, I think, is largely going to continue the trend of CCPA. But I will say, after 2 years, my experience is these are cases that can be fought and can be won. And if not, you may be able to settle them on reasonable terms. Mitigation, I mentioned arbitration provisions, and this is the place I'm going to stop. I'm going to go through contract formation and arbitration. I know I'm almost out of time, or maybe out of time, but indulge me if you can. This is an important issue and some important online contract and arbitration cases I want to talk about. In general, the trend continues that even though implied assent is a valid way to form a contract, as we learned in first-year law school, courts are much more comfortable with express assent. Now, we have a very good First Circuit decision from 2021, the Emmanuel v. Handy case, enforcing terms of service and an arbitration provision where the plaintiff selected accept in a mobile app. Very, very good decision. And we have an array of cases where if you have a button and it says accept, you'll be good. It's, you know, the gold standard is scroll down, check a box next to clear messaging, press a button. But of course, you don't have to do all of those things. But when you don't, that's when litigation arises. This is an older case involving Uber, where there wasn't a lot going on here, but the language was next and register. Second Circuit said it's clear. A reasonable consumer is not someone who's never entered a contract online. Actually, you have to assume a reasonable consumer has entered into a contract. And so underlying terms of service and privacy policy, in blue, a reasonable consumer knows is terms of use, and this is adequate notice. Now, I have to say, in the past year, there have been courts that have said if something's underlined in a different color, maybe a consumer doesn't have notice. That's crazy. But what it means is when a decision is rendered from a transactional perspective, you are better off following that decision. Put your links in blue, because if you put them in green or something equally prominent here in a box in white, with a gray thing, the First Circuit said, well, the Second Circuit said underlined in blue is reasonable notice. This wasn't blue. Crazy, crazy decisions, but these things come up. So the more you can hew closer to the gold standard, the better off you are. It is hard to enforce implied terms, and indeed in the Ninth Circuit, both in website and in mobile apps, you may not even be able to state a claim. Now, in litigation, I have some strategies for dealing with that, because oftentimes you have to establish a contract at the outset to win a motion to dismiss or to compel arbitration. But it sets a high standard. So let's talk very quickly about mass arbitration, arbitration claims, and some drafting tips from 2021 case law, because there are some important developments. The easiest way to avoid having to spend a lot of money and time with people like me defending data privacy, cybersecurity breach, and TCPA and ad tech class action suits is to have a binding and enforceable online contract or terms of use, and you want to make it enforceable if you have a delegation clause, either explicitly or by incorporating by reference AAA or JAMS. Then most issues are delegated to the arbitrator, even common threshold issues. But you need to be aware you may not always want things delegated to the arbitrator, because if you're subject to a public injunction claim, that may be delegated to the arbitrator. Under the McGill test, you cannot, a consumer cannot waive a right to bring a public injunction claim. So you really have a couple of choices. You have to implicitly or explicitly make it arbitrable. That may be good, or you may not want an arbitrator deciding those issues. Or you need to carve it out. If you carve it out, you might want to put a provision where the consumer agrees to a stay, that issue will not be litigated until the issue, until the rest of the case is arbitrated, and that can sometimes slow things down. Important 2021 case law, though, very, very important. Capriola v. Uber from the Ninth Circuit. Injunctive relief seeking reclassification of Uber drivers was not a public injunctive relief claim. Similarly, the Carleby money lion. What the Ninth Circuit has said is if something applies to your company, very narrowly, it's not a claim for public injunctive relief. So actually, in the Ninth Circuit, you may prefer to have a judge rule on whether something is or isn't a public injunctive relief claim. And if you have a delegation clause, maybe that goes to the arbitrator. So something to think about for your drafting. The other issue is mass arbitration. There have been a number of claims brought where plaintiffs advertise. And if you've got a good consumer brand, there are class action lawyers, they advertise, hey, do you have a claim against company X? Click here to sign up. And then plaintiffs present hundreds or thousands of claims. Now, if you're subject to JAMS or AAA, you may have some issues because you may need to revise your arbitration clause, or you may consider other providers like FedArb or others that have special procedures for mass arbitration. Not everyone faces the risk of mass arbitration, but if you do, it can be expensive. And it can be expensive because you may end up having to pay thousands of dollars in non-refundable fees for hundreds or thousands of claims. And so it's the fees that are important. As a drafting tip, I would always put in a mandatory negotiation period, maybe even also mandatory mediation before anyone can bring a claim, so that you at least have an ability to discuss that issue. But it's something to consider and something to take in mind and update and review these carefully. The law changes a lot. Where we sit today is different from a year ago. And so I would urge you to look at this at least annually, if not every 6 months. Let me stop at this point because I know I am out of time. I will take questions to the extent you're able to stay on the line. And I will also take questions offline. If I didn't answer something, if I didn't get to something, if something I said was more confusing, please please feel free to reach out to me. It is always a thrill to speak to ACC. Let's hope next year we can do this live again. It's even more fun when I can talk to people directly, even though I appreciate some of the some of the messages that people have sent. I do have a question for those of you who are able to continue on the line. In considering the work product doctrine, do you have insight on the current law about timing of litigation holds? Well, timing of litigation holds, I tend to think, you're always safe with a conservative approach, and that is important. But in terms of, I think that's sort of generally it. Obviously, you need to look at the specific circumstance you're dealing with. But litigation holds can be important because spoliation can be a big risk in litigation, and class action lawyers are very sensitive to it. In cases where they may lose on the merits, if they can get a spoliation inference, there's a real risk. In litigation, I have some tricks and tools you can use to try to shift the burden to plaintiff or notify them in a general way or specifically early on so that they can't later turn around and say you should have preserved things. But when it's outside of litigation and you're just holding, again, it depends on the specific facts. The presentation slides will be shared for those who ask questions. I think I've answered all the questions at this point. So let me turn it back to Paula and to Carrie. And again, thank you all so much. ACC is a great organization. I always love talking to ACC, and the courts, Congress, and others always give me far too much to cover every year in talking about year-end review.
Thank you very much, Ian. This is Carrie from the ACC SFBA. Thank you to everyone for attending. We will be sharing a copy of the presentation materials as well as a recording of this session, so you can refer back to it following the session. We'll also be distributing CLE certificates. There's no code necessary. We're able to track your the time spent on the call, and those will be going out in the next couple of days along with the survey. And if you did have a question and we didn't get to it, or you have a follow-up question, we encourage you to reach out to Ian directly. He would be happy to answer for you or to you directly following this. And we look forward to future presentations from Ian and also from other members of the team at Greenberg Traurig coming up this year. So thank you very much.
Thank you, everyone. Bye-bye. Have a great Have a great rest of your day.